not only its letter and spirit, but in its practical approach. When working as a judge of a consumer court, I have noticed certain facts which I wish to share with you. As an academician, all the respected teachers, principal ma'am, and you all also are aware that the consumer is a king. That is later written in the books. But in practice, when we see, are you agree with this proposition of law that whether consumer is a king or not? How many of you agree or disagree? Can you raise your hands? Who are agree that consumer is king? Few. And who are disagree with this proposition of law? So the number is equal. So we may take this 50-50. So few of you are agree with the proposition of law that consumer is king, means rights of consumers are meaningfully enforced and protected. That is what the literal meaning of that word, king. And few of them are not agree, that they are not meaningfully enforced and rightly protected by the laws in the books. So if we find out the reasons why the consumer is not the king, we can conveniently assert this fact that the consumer is not made aware of his rights. This is the very essential thing we need to understand in its first place. When we stand to discuss the provisions of Consumer Protection Act, first of all we need to know who is the consumer. Today I may not deal with the legal provisions because this is a discussion about the concept. As I stand for the first time before you, so I should not go into the legal niceties of the act, but I need to interact with you more so that you open your mind and start thinking on this particular aspect of who is the consumer. The main aspect behind the incorporation of this act, if we consider the age-old history, it relates to the law of torts. As we all are law students, so we are aware that when the consumer movement was begun, it was the law of torts has taken place. That law of tort is a civil wrong, and for every civil wrong there should be some remedy. As we are aware, it is a civil remedial. So that we have studied as a student of law. That if there is no remedy, then the law is of no value, has no avail to anyone. So to protect the rights of a consumer, the beginning of this movement was translated into unifying this concept of consumerism. If we consider this movement, it was begun by the John F. Kennedy, and the main aim behind this movement was to ensure that consumers are protected, because it is seen even today that the service providers, they are united, but the consumers are not united. The reason is that the consumers are not made aware that they have certain rights. As we study in the Constitution of India, from Article 14 to 19, there are certain freedoms are given. Freedom of speech and expression. As well, Article 21 speaks about right to live with dignity and all. But how many of we exercise those rights? Very few have the access to these fundamental duties, fundamental rights, and are aware of these rights. So we never fight for our rights. This is what the activity of Indian consumer. And to ensure that the consumers have meaningfully enforced their right, the beginning movement by John F. Kennedy was translated in India by late Bindu Madhav Joshi in the year 1982. They have drafted, with the help of other experts in the field, a legislation, and it was presented before late Prime Minister Rajiv Gandhi in the year 1985. And they told that this is the legislation which will, according to their organization, will help the consumers understand their rights and enforce them meaningfully to protect their rights. The then Prime Minister directed the ministry to enact the act, and the codification was done accordingly. And in the year 1986, on 24th December, the old Act 1986 Consumer Protection Act was passed. If we see the provisions of that act, all the provisions ensure that the consumers have the required to be united, and their rights are protected not only meaningfully but in its lawful manner. If we see the provisions of Consumer Protection Act, we will see certain definitions which help us understand that why the consumer is important. The better protection of consumer interest was the legislative intent, because if we want to know the law or any act, we need to see the legislative intent behind the act. So if we see the legislative intent behind the incorporation of 1986 Act, we will notice that the consumers are not united, and therefore to bring them united, because we have accepted that unity is the strength and is equally being done by the service providers. So better protection of consumer interest was the main legislative theme or intent behind the incorporation of the old act. If we see the word better, we came to know that they are deprived of certain things. Why we give a better protection? We don't see, if we consider the provisions of Consumer Protection Act, the protection to be given to the consumers, we see always a better protection to be given, because the service providers are united. There are certain reasons why the word better is used and why the consumers are required to be protected. You will never find such legislative intent in any other act, that to give a protection. Take a case of other acts relating to child. The word protection is not there. Why the protection is there? Because they are deprived of certain things. The service providers, they are united. They are framing their policies according to their whims and fancies, their wish, and they are cheating the consumers there. If we go to a bank or to an insurance company, they will give a printed format and ask you to sign on the format. They don't give you a right to change the terms and conditions. And when the case comes to our court, they say that we have agreed accordingly. So whether that agreement is fit by the provisions of Indian Contract Act, Section 13, if we see the provisions of Indian Contract Act, which is the basis to understand the Consumer Protection Act, because every case before the Consumer Protection Act or under the Consumer Protection Act or before the Consumer Code comes under a particular contract, arising out of a contract. So student of law who approaches to a consumer court must go through the first provisions of Indian Contract Act, Section 2D consideration and onwards. And thereafter, we should consider whether there is a deficiency in service or whether the terms agreed by the consumer are complying with the conditions provided under Section 13, Section 14 onwards. The pre-consent is given. If the consent is caused by coercion, undue influence, fraud, misrepresentation or mistake, the consent cannot be said to be pre-consent. So always it is seen whenever you enter into an agreement with the service provider, that your right to choose your terms and conditions is given by the provisions of that particular agreement. So all the agreements entered by the consumers as on date are printed formats displayed by or prepared by the service providers. The consumer has no duty to change the terms and conditions of the agreement. Therefore, in my respective submission, that all the agreements which are printed are hit by the provisions of Section 13 as well as 14 of Indian Contract Act. So unless the consumer is made aware that you can change the terms according to your choice, you can change the nomenclature of the particular word, you can have the access to your vernacular agreements, and unless you exercise your right to that extent, the service providers are bound to cheat you. Therefore, it is our duty as a student of law to make these rights aware to the consumers. Whenever there are printed forms of agreements, you should approach to the service provider, explain him that he is not bound to prepare the printed agreements, because the definition of agreement, if we see, that it says that an agreement enforceable by law is a contract. So if that particular agreement is with by the provisions of section 13 and 14 onwards, then it cannot be termed as an agreement. It cannot be enforceable in law, because the service provider himself has prepared and the complainant or the consumer has only signed the agreement without knowing the consequences of that particular word. So this is the first duty of as a student of law, that we should make the consumers aware that you should not sign on any printed agreement. Then and then only the service provider will take notice of this. Otherwise, in routine course, if we go to the bank for availing a car loan, home loan or vehicle loan, the printed format is there, you are in need of that particular service by the bank, or you oblige that the bank is giving you the loan. It is not, it is your income tax which gives you the right to avail a loan. The bank is not obliging you by giving a loan. And I beg to apply for the loan. That is wrong. Because bank is doing its business. In business, there cannot be begging or explaining your inability by accepting that particular right. So we should try to take this notice that the word begging should be removed from that. The bank is, you are income tax payer, you have shown your documents to the bank, therefore bank is giving you the loan. This is the legal concept rather. But in practice, we pay for the managers and all these people who give us the money. And we are begging something. You are not begging, the law gives you the right. You pay the income tax sincerely, therefore you are eligible to avail the loan. So these are the niceties of the things which we should understand. Accordingly, in another case, when you go to the particular shop to buy a particular thing, you have every right to ask for the reduction of price. Did you exercise at any time this right? Have anybody has exercised this right? Can you share the experience that you bargain on something? We'll have that in question answer pattern. Therefore, it is our duty to bargain for the price. So the 6 rights given under this act, did we exercise them at any point of time? If not, then we as a student of law did not exercise. How we can expect from the society to exercise them? It is our duty. Charity begins at home, that we have accepted. So we should start on our own. That we should bargain at a proper place or a bargain for a particular thing. When we did not exercise that particular right, how we can expect that others should follow that? We should be an example. When we represent in a society as a lawyer or as a student of law, we should be an example for others. That is our duty. Because we all are law-abiding citizens. We follow the law, we study the law, not only to earn the money or to become a lawyer or to become a judge or to become a happy married life. It is our duty to strengthen these laws. We are the protector of these laws. When we appear in courts, it is not your duty to explain the case of your complainant, but equally you owe the responsibility that to strengthen the law, to help the legal system grow well. Because the growth is everywhere. It is a natural phenomenon of that it will grow gradually. You practice in any court, the way you develop your logical thinking, interpretive skills, and knowing the genesis of these laws, that will help you grow well. Therefore, it requires you to understand the legal provisions in its step-by-step way. Unless you apply your logical mind and interpretive skills to that particular concept, it is impossible that you will be living with the law. Similarly, when we consider the new provisions, the 1986 Act was repealed on 20th July 2020 and the new Consumer Protection Act was brought after 22 years. Now we will consider why this change was brought by the legislatures. In the old Act, the consumers' rights are mentioned, but there is no mechanism except the consumer courts to exercise them by the consumers. There is no proper remedies available for the consumers as well. There are no controlling authorities which will control the deficiencies delivered by the service providers. Therefore, the new authority, Central Consumer Protection Authority, was established in the new Consumer Protection Act. The role of the Central Consumer Protection Authority was twofold. The first is to regulate the consumers in various types of deficiencies dealing with the service providers as well as the defects in the products. The main other concern was that there are two types of deficiencies. Deficiencies in services when you avail a particular service, and apart from your agreement, if there is a deficiency, then in case of deficiency you can approach the consumer courts. And the defect with respect to the product. Suppose you bought a mobile from a particular shop and it was not as per the specifications which you require. Then in such cases you can approach to the consumer court and can file a case against the service provider or the manufacturer for the defect in the services. Defect in the product means defect in the services, because it is the duty of the manufacturer to declare the defects in the product. If it has certain specifications, you find after using or during use of the product that it doesn't comply with the specifications or the required comparisons. So in case that you can find the consumer complaint. So the controlling these product manufacturers to provide the services to the consumers according to the requirements of the consumers, that is one of the essential duty of the Consumer Council. That Central Consumer Protection Authority has another aspect of misleading advertisements. We see day in day out in the newspapers, on the boardings, by electronic media and all that and everywhere, that there is advertisements to give the consumers free. Nothing comes free, that is no, but still we go for the free. Knowing well that nothing comes free, we approach to the free. Some advertisement is there. Amazon, Flipkart, others, these platforms where we buy normal goods. So they give some offers to you that something is free. So you log in, you pay the money, and you got nothing free. Then in such cases, if we approach to the consumer court, you may not be able to prove because court requires proof. You may not be able to prove that it was free, because that free, no sooner you apply for free, it is disappeared. You cannot have the option to have a screenshot or keep record of that free. So because we have adopted the system, judicial system or administration of justice system based on documentary proof. All your oral submissions, okay, it is for oral arguments, but the judgment will be delivered based on the documentary evidence. So you may not be able to prove that that was free when I applied for it and I did not receive it. So all these aspects, why these people are doing this thing? Because they know that if they don't give any proof regarding that, they will not be punished or you will not be able to do it. So the Consumer Council Authority, Central Consumer Protection Authority, has every right to penalize these misleading advertisements. So in courts you may not be able to prove them, but the authority has its own investigation wing. They investigate into these scams and they penalize them. Recently they have penalized one celebrity, I did not name here, one celebrity for misleading advertisements, and that advertisement has stopped. So we have certain experiences that the consumers, they are being not granted. There was always scope for the service providers that could look the consumers for so many reasons. So the Central Consumer Protection Authority, which was established under the new Consumer Protection Act 2019, has its own investigation wing. They investigate into the affairs of these service providers and misleading advertisers, and they penalize them and direct them not to publish such misleading advertisements. Similarly, in the new Consumer Protection Act, another important aspect of e-commerce was introduced. Earlier, we used to buy and sell the things on electronic apps, and we pay them, we receive the product. However, while doing that, there were no controlling rules as such. The e-commerce protection rules were introduced in this new act in order to protect not only the consumer but to the service providers also. These are the neutral rules for both the parties. Now, if we order before enactment of this act any product from Amazon or Flipkart, there was only a customer care number, and it was in normal course it was not working. But now, if we order, we will get the detailed address who has manufactured the product, he will get their helpline number, email address. Every details, minute details were mentioned on the box, even on the receipt. Earlier this was not there. So the e-commerce protection rules were introduced in order to protect not only the consumers but also the service providers. Earlier, whenever a case was filed before the consumer court, only the name of the opponent as a Flipkart or Amazon and the customer care number was mentioned. Because in absence of address, they have accepted the products, they have placed an order. Cloudtail or something, some name was there, but it doesn't have the address. So it was very difficult for the consumer to file a case. Being address of the opponent was not there, the complaint kept pending for want of address, number of days and number of years. But now the detailed address was there, so the notice can be served to the opponent in case of there is a defect or deficiencies in the services by the service provider, and the consumer complaint can be conveniently disposed of according to that. So this was the change brought by the e-commerce rules. They have defined the e-commerce entity. Who are the e-commerce entity? So the e-commerce entity as defined under this act is this, that the consumer who has approached to the any app or any electronic device by any means, maybe it's website, maybe it's app, maybe it's other sources by which he has a knowledge or he wants that product to be bought. So all these entities who are made themselves available for electronic sell and buy things, because they also buy from something. Suppose Flipkart or Amazon is selling to you, they also buy the products after you place an order. So if we see the track of this, when you order something, your order is booked, thereafter your product is received by the facility center. Normally it is in Pune, and thereafter they deliver it to Pune and it will be sent to you. Means once you place an order with the Flipkart or Amazon, they will place their order to the seller and they got the product and then it delivered. So this mechanism, this was earlier it was there, but it was not regulated by any law. Now this e-commerce protection rules have regulated this conduct of their working, and it is always seen that the rights of consumers are protected by doing all this. So there is another instance that in case of refund, suppose you order any product and you have returned it within the reasonable time, 7 days or whatever days is permissible according to the nature of product. Once you return, your refund will be, it was mentioned that your refund, you will receive the refund after 7 or 10 days or 15 days. If in case you did not receive, you can raise a complaint to them that I did not receive. But what about the interest? If you did not receive the refund within 7 or 15 days, did they pay you with interest? There is no provision of interest. So you need to file a case in case you receive the refund after the prescribed date or prescribed period for the refund or the interest in the consumer court, because that is a gray area in which we need to educate ourselves. We need to see that the service provider should not take advantage of, there is no interest, they can pay you after 1 month or 2 months, because then they have to pay that particular amount only. That is not without interest. So as a student of law and as a consumer, we should see that what are the loopholes in this new Protection Act, Consumer Protection Act, and always deliberate amongst that these are the things which are left when the new act was brought into force. So we should always think the law, that what is the law, what is the social situation, what are the personal experiences of you people or as a consumer, and what changes required to be brought into the new act. So the duty of a law student is equally to read the law, to understand the law, to see that it is implemented, but it is equally important that to suggest amendments, suitable amendments, and you should have a deliberation per month that take any act and discuss with your senior professors, your respective principal man, that I have studied this particular provision and I think that the law is absent in this particular, as I have explained you, that there is no payment of interest if it is paid belatedly. So it requires the amendment should be made in the e-commerce rules that if the delay is there, then there should be a 24% interest or 18% interest. The interest should be higher side. It should not be 6 or 9% or 12%. Unless we brought this change in the present act, the service provider may not pay it at this regular period or whatever be the period there. Similarly, there is another important change brought by this new Hon'ble President Act with respect to product liability. We have studied that the magazine that caveat emptor. How many of you are aware of the meaning of this word? Caveat emptor. Can you stand one and explain? Yes, sir.
Let the buyer be aware.
Let the buyer be aware. Can you cite an example?
Whenever we are buying something, we should at least check if the product is right or not. We should not blindly buy it. For example, if I am buying a phone, at least I have to check if all the things are working, if the camera is working, if the battery is working, if it's charging properly or not.
Yes, correct. So this is the meaning of caveat emptor. And now the change brought by this new Consumer Protection Act was also one magazine. Anybody? What was the change brought by this new Consumer Protection Act with respect to product liability? Or I will give you the hint. Exact opposite to this magazine. What is this magazine? Yes. Can anyone explain? Yes, sir.
Exactly opposite to what the caveat emptor is, that the seller be aware. Seller should take proper care while selling, and he should take good care.
Can you cite an example?
Like when the seller is selling some goods, so what he is selling, what he has ordered from the manufacturer or bought from the manufacturer, he should check, and the duty lies on the seller by selling that whether the goods are proper or not.
And he has to explain to whom?
The buyer.
That is important. Yes, correct. So the exact opposite to this magazine. Earlier act we have noticed that caveat emptor was the rule of law, but now from 20th July 2020 it was a caveat emptor, and the seller's responsibility is casted as earlier it was of the consumer. Now if we explain or to understand this magazine caveat emptor with respect to the product liability in the new Consumer Protection Act. Earlier it was the seller's duty that to give them the product. Suppose you enter into a mobile shop, the seller will show you the mobile phones and say that these are the, and he will explain the price of it. That these are the from range 10,000 to 20 and onwards and whatever. So you need to Google at home and approach to the shop, and according to your money you need to buy. So earlier it was a money oriented bargaining or money oriented purchase. That was under old act. Because you should have you want to save the money, then you have insufficient knowledge. But now it was a exact opposite, that it was a product oriented bargain. The seller, apart from the money, has to explain you that what is your requirement. He has to ask you your requirement. Many of you have bought the laptops from the reputed shops or from other shops. So the specification, the company is different thing. But what GB is required, what RAM, you want the gaming option or what are the Android and other options. So that was your knowledge, you explain to the seller and he will explain you these are the things in this. So you can't play game on this. So for gaming you have to go up or some around 60,000 or onwards. So it is the duty of the seller to explain the specifications. So now this is protected and this was regulated under this new Consumer Protection Act. The magazine caveat emptor not only help the consumer but to seller also to explain the product, and if he fails to explain the specifications of the uses of the product, then in such cases the consumer can approach to the Consumer Commission under the product liability clause having regard to the deficiencies or defect in the product. Suppose if he said that this you can play the game on this laptop and it was not working, but you